Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration. Shopping for immigration law software? Don't let shiny demos cloud your judgment. Before you choose a platform, ask the questions that really matter about security, support, and the fine print. E-Immigration's free checklist, 20 questions to ask before choosing immigration law software, gives you the exact prompts to cut through sales, spin, and get real answers. Save yourself time, headaches, and buyer's remorse. Find it at offers.eimmigration.com/vendor-QA, courtesy of e-immigration. Or please, click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Good morning, everyone. If it's not morning, I wish you a good whatever it is. And a happy No King's Day. I hope you enjoyed your protest. Before we get started, I wanted to share an email from regular podcast listener F. Evan Benz, the senior attorney at the Immigration Impact Lab with the Amica Center for Immigrant Rights. Always grateful for emails from Evan and anyone from Amica, and anyone really. Evan writes me as such. First, he wanted to make sure that I'm sane in these crazy times. Everybody does. And he wanted to share an immigration-related case that he thought might be interesting for me. He was right. This week in CBP et al., the Nexus Services et al., the Fourth Circuit upheld an $811 million judgment against Libre by Nexus and several individuals involved in the company for, quote, a nationwide fraud scheme that preyed on vulnerable and distressed immigrant consumers by marketing their product to the immigrant consumers as an easy and affordable method of securing release from ICE custody on immigration bonds. But in reality, the Nexus defendants charged the immigrant consumers exorbitant fees for a purported array of services and deceived and abused those immigrant consumers in violation of federal and state consumer protection statutes, end quote. Thanks for sharing, Evan. And great to see how suing the federal government and corporations that work with the federal government can secure change in immigration policy. My hats are of course off to all of us in federal court right now, making change through lawsuits and doing all they can to stop the U.S. government when the U.S. government violates the law by litigating in habeas, FTCA, mandamus, or anything else available to our very creative bar. And of course, I'm always happy to get emails from all of you, especially when you've got interesting things to tell me about your case or another case that I may have missed, because I am human, despite what you have heard in these crazy times. I'm always happy to hear from everybody. Now you will hear from me with my 3 cases. Our first case is Ramos-Ramos v. Bondi, published by the 10th Circuit on October 15th, 2025. As I think I've mentioned before, the 10th Circuit doesn't publish immigration cases that often, but when it does, it often goes big. This decision is no exception. It's about asylum and much more. The case has been going on for 11 years. Ms. Ramos and her 2 minor sons have been granted asylum by an immigration judge 2 times. The BIA has reversed 2 times. The 10th Circuit is having none of it and outright granted Ms. Ramos asylum in this decision. Perhaps unsurprising, though, given that, quote, the government does not attempt to defend the BIA's decision in this appeal, end quote. And yet, 44 pages to get there. Let's dive in. The family is from Honduras. Miss Ramos was with a Mr. Robles in Honduras and went to a party with him. They share 2 children, and Miss Ramos has 2 more from another relationship. That night, they were awoken by an acquaintance of Mr. Robles who played soccer with him, named Jonas, who it appears is a member of or has connections to an MS-13 affiliate gang called an Estrova. Jonas convinced Mr. Robles to come outside, and then he was found partially decapitated the next morning. No one really knows why, but it's believed that Jonas and other members of the gang or associates of the gang hated Mr. Robles for reasons related to soccer. Police did nothing when the murder was reported, but Jonas kept hanging around, always watching Miss Ramos and warning her that he'd eventually kill the children like their father was killed. Jonas even dared Miss Ramos to go to the police, confident that nothing would happen to him. Miss Ramos nevertheless tried a month later, but to no avail from the cops. She believes it was because they themselves have gang ties. So Miss Ramos and her 2 minor children, seemingly the children of Mr. Robles, fled to the United States in 2014. The other 2 children who are not Mr. Robles' children remain safely in Honduras, as do other members of Miss Ramos' family, and they have never been contacted by Jonas or anyone else. Then again, explains Miss Ramos, none of them have connections to Mr. Robles. Miss Ramos and Mr. Robles' brother testified in immigration court, and Miss Ramos, through pro bono counsel, appears to have filed a fair amount of country condition evidence and an expert report. And an IJ granted asylum to this non-criminal, scared mother and her children. The particular social group was nuclear family of Mr. Robles. On DHS's appeal, the BIA wanted more facts found, and so remanded. 3 years later, the IJ obliged and granted again, with more facts found, it appears. This time, the expert actually testified in court, by the way. DHS, with a bee in its bonnet, appealed again, and 4 years after that, the BIA said screw it, the IJ committed clear error on nexus, reasonable relocation, and the Honduran government's ability and willingness to protect, and remanded for Convention Against Torture analysis, saying asylum and withholding off the table. Miss Ramos, however, petitioned for review the denial of asylum and withholding of removal to the 10th Circuit right away, despite the CAT remand. Kind of weird considering that there's no technical final order of removal, right? But emails with counsel in this case indicate that it was to account for the forthcoming Riley decision, to preserve jurisdiction of the withholding of removal denial if the Supreme Court came out the wrong way there. Which, of course, the Supreme Court did, but heck, I'm not even sure that it's necessary under the Riley decision that was published. I'd need to do a bit more thinking there. But it was certainly a safe move back then. Petition for review the denial of asylum and withholding, and then litigate CAT on remand. But then on pseudo-agreement with ICE, Ms. Ramos withdrew her CAT claim before the IJ, and a second petition for review tethered to the final order of removal went all the way up to the 10th Circuit, and they're now together in this decision. Ms. Ramos' opening brief was so convincing that the government didn't file a response, and instead moved to remand so the BIA could get a do-over. The 10th Circuit did not grant it and seems to have permitted OIL to then file a response, which is quite kind of the 10th Circuit, but OIL simply then reiterated its position in its brief that a remand to the BIA was in order. Ms. Ramos submitted the easiest reply brief ever, and here we are. I'm skipping over a lot of complicated procedural history here due to the multiple petitions for review that touch on very thorny issues of appellate procedure, and the court ultimately doesn't even really answer those questions. So if you're a masochist, by all means, pages 10 to 15 of this decision are for you. And despite OIL not defending the BIA's decision, the court went through everything. The BIA reviews IJ fact-finding for clear error, and that is a high standard, explains the 10th Circuit. And despite citing the correct standard in case law, well, the court doesn't believe that the BIA practiced what it preached. For example, clear error means that, quote, if a view of the evidence is permissible, that view cannot be clearly erroneous, end quote. Emphasis by the court. Or as I always try to remember, for the BIA to reverse on clear error in the First Circuit, the IJ fact-finding must stink like a multi-week-old dead fish. Their words, not mine. In contrast here, explains the 10th Circuit, what the BIA did was closer to de novo review, and that is a big difference. First, nexus. The IJ believed that family relationship was one central reason for the harms suffered and feared, but the BIA didn't. In so finding, however, the Tenth Circuit flat out believes that the BIA just misunderstood the IJ. Seems like OIL believes that too. Honestly, it's not even worth getting into because the BIA simply misunderstood what the IJ found and then reversed it. So that's clear error. To the extent the BIA didn't just screw up on nexus like that, its reversal isn't based on clear error, explains the Tenth Circuit. Yes, the IJ relied on circumstantial evidence to conclude that familial relationship was one central reason for the Jonas stuff against Ms. Ramos and her kids. And yes, maybe that stuff alone doesn't necessarily compel a grant in all cases. But that the nexus finding wasn't a permissible thing for the IJ to do? No way. The IJ wasn't crazy to view the circumstantial evidence in Ms. Ramos' favor. For example, and unlike the IJ, the BIA believed Jonas's threats, quote, extremely vague, end quote, but reversing for that reason, quote, is tantamount to saying the BIA would have weighed the evidence differently or decided the facts differently had it been the fact finder, end quote. That's not clear error review. Even believing the IJ, quote, probably wrong, end quote, is not sufficient to reverse, explains the Tenth Circuit. It's got to be clear. Of note to the Tenth Circuit, and maybe your case, reasonable for the IJ to find nexus met given, quote, Jonas's references to Mr. Robles in his threats, the fact that the threats began only after Mr. Robles' murder, and the fact that Ms. Ramos had heard the threats directed at everyone within the asserted particular social group and no one outside it, end quote. On to relocation. And actually, this isn't a past persecution claim, apparently. It's a straight, well-founded fear of future persecution claim, meaning that Ms. Ramos retains the burden on relocation. Met! Or enough to survive the BIA's reversal, explains the court. Here, too, the BIA misconstrued the IJ's careful findings. Yes, the IJ believed MS-13 and by extension Jonas and the sub-gang had reached throughout Honduras, but the IJ never found that Jonas was necessarily a member of MS-13, and the BIA chastised the IJ for having done that finding. Rather, it's all based on the record showing the reach of Jonas and his gang friends based on Jonas's gang connections, and no one can test that he had those. Maybe the BIA wouldn't grant this case, reasons the Tenth Circuit, and maybe you wouldn't either, who knows? But it's not clear error on the IJ's part, particularly as, again, the BIA appears here to keep building houses of cards to knock down. Of note as well for your future cases, and in addition to some other stuff, it was reasonable for the IJ to conclude relocation unreasonable, given that, quote, Ms. Ramos' status as a single mother and relationship with Mr. Robles, with whom gang members had a feud, make her especially vulnerable, end quote. Finally, then, on the Honduran government's inability or unwillingness to protect, something Ms. Ramos must show because she doesn't claim to fear the Honduran government itself. Hard to show how the IJ was clearly erroneous there, with all the testimony about police apathy and the expert and other country condition evidence about Honduran police, right? So the BIA's discounting of those events as simply, quote, frustrating interactions, end quote, and reliance on the fact that the Honduran government has embarked on anti-gang efforts at a high level, just isn't that appropriate thing for a purported appellate body to do. Quote, crediting some record facts over others is a quintessential example of reweighing evidence on appeal, a function the BIA's own regulations squarely prohibit, end quote. And you know the pattern I'm using in this decision by this point. Of note for your cases, quote, the leap from Ms. Ramos not being heard by police to her not being sufficiently protected by police is not large, end quote. Emphasis by the court. And actually, I've got more on this, quote, we note Ms. Ramos credibly testified that the police did not do anything to track down Jonas after he murdered someone. We struggle to imagine better evidence of police being unable or unwilling to help protect against Jonas, end quote. Does that fact exist in your case? With everything addressed favorably for Ms. Ramos, we still have 13 pages to go in this bad boy, and they're all about what the 10th Circuit should do with this mess. I'll cut to the chase. The BIA will not be getting a third shot because, quote, the correct outcome is beyond doubt, end quote, in a case that has already lasted over a decade, explains the court. And it makes sense, right? There aren't new facts or legal arguments, and, quote, the BIA does not need a chance to redo the same inquiry it already fully undertook, end quote. Emphasis by the court, and perhaps helpful for your petitions for review if you just want a flat-out grant of asylum. Agreeing with the 8th Circuit that, quote, no immigrant should have to live over 10 years with the uncertainty as to whether she can stay in this country or not, end quote, the 10th Circuit granted Ms. Ramos and her children asylum and paths to U.S. citizenship. Technically, I guess they reinstated the IJ's grant, but who's tracking? Who's even paying attention to me at this point? And all of it means mega congratulations to Brandon R. Gould of Covington and Burling, as well as Patrick Terrell and his team at Grossman, Young & Hammond, LLC, on this very hard-fought win. Seems like everyone was pro bono for a very long time, too. Here are your flowers. And that is Ramos-Ramos v. Bondi. Next is Pastor-Hernandez v. Bondi, published by the 6th Circuit on October 17, 2025. This case is about motions to reopen and voluntary departure. Mr. Pastor-Hernandez is from Guatemala. He is Quiche Mayan and fled to the United States at 17 years old to escape gangs in 2014. He was served with a purported notice to appear the day after he entered the United States and sought asylum and related relief and protection in an immigration court, but an immigration judge denied. The BIA affirmed. But during all of that, the Supreme Court issued in Chavez, which is relevant here, held that the INA's stop time rule isn't triggered by a notice to appear or follow-up notice of hearing, where the NTA doesn't have all the information required of NTAs by INA Section 239A, such as the date, time, and location of the first removal hearing. What that meant here is that Mr. Pastor-Hernandez became eligible for post-conclusion voluntary departure under INA Section 240BB, which requires, among other things, that non-citizens be in the United States for at least 1 year before being served with an actual NTA. BIA and other circuit precedent holds flat out that Mr. Pastor-Hernandez is totally right. He became newly eligible for post-conclusion voluntary departure because of Ms. Chavez. So he moved to reopen his case. He wanted to leave the U.S. on his own, it seems, and avoid a removal order and the attendant bar to re-entry. Everyone seems to agree that he's now got the 1 year. But the BIA denied his motion to reopen. Because to get voluntary departure, one also must show, among other things, that they have the means to depart the U.S. on their own, which often just means proving that you've got a passport and a little bit of money. Mr. Pastor-Hernandez, however, didn't have a current passport. He was in the process of renewing it. He explained to the BIA under oath in what seems to be a short affidavit. It wasn't good enough to the BIA, in part because he didn't provide any evidence that he had applied to renew that passport. Just a terse statement, it would seem. So that is the riveting issue we have. The Sixth Circuit affirmed the BIA. Almost held that it didn't even have jurisdiction to review the issue given how discretionary voluntary departure is, but at least here it believed it could review the denial of the motion to reopen, given that Mr. Pastor-Hernandez wasn't challenging a purely factual finding, such as whether or not he actually possessed a valid Guatemalan passport. Rather, his claim was whether testifying that one is in the process of getting a passport sufficiently meets the voluntary departure and motion to reopen requirements, such that denial of a voluntary departure-based motion to reopen is legally proper. A fine line, but an important one for jurisdiction. But insufficient to win on the merits. All agree, after all, that he didn't meet the requirements of having the means to depart the U.S. when he filed the motion, even if he might in the future. Quote, "This statement reveals an important question. May immigrants file motions to reopen that seek relief based on future facts?" End quote. And it's true, motions to reopen are all about showing future facts. The idea is that given the chance, the non-citizen will be able to prove something, such as termination of his case, eligibility for relief, etc., in the future. But in all such cases, a motion to reopen still requires a showing of prima facie eligibility at the motion to reopen stage itself. Gotta make an initial prima facie showing of all elements you're hoping to satisfy if reopening is granted. That you're reasonably likely to succeed if given the chance. Mr. Pastor-Hernandez, in contrast, didn't even make a prima facie showing of having the means to depart the U.S., reasoned the court. He just swore that he would have the means, he would have the passport, in the future. It's a close call, the court admits. After all, the motion to reopen statute itself reads that, quote, "The motion to reopen shall state the new facts that will be proven at a hearing to be held if the motion is granted, and shall be supported by affidavits or other evidentiary material," end quote. So it kind of supports the argument that a purely future-oriented showing is permitted and that an affidavit should suffice. The Sixth Circuit actually kind of punted on precisely what kind of showing is required for a motion to reopen and affirmed the BIA on a narrower ground. Mr. Pastor-Hernandez didn't even provide enough evidence that he would have a valid passport in the future. He just provided a conclusory statement that he was in the process of getting a new one. He didn't provide evidence of how he met the requirements to get a Guatemalan passport, what he had done to get it, or provide evidence that the application was pending. Even assuming a pending passport application could establish a prima facie case, and it's possible, Mr. Pastor-Hernandez didn't provide sufficient evidence that a passport application was pending. Riveting stuff, I know. In so holding, the Sixth Circuit includes a discussion that would seem to undercut the power of affidavits during a motion to reopen process, at least where conclusory and not detailed, as this one apparently was. The affidavit here was nothing like the detailed and specific affidavit that won the day in a motion to reopen in the Sixth Circuit in the 2018 decision Trujillo-Diaz v. Sessions, should you need a more favorable affidavit-based motion to reopen decision to cite, explains the court. As to Mr. Pastor-Hernandez, the Sixth Circuit denied his petition for review. And that is Pastor-Hernandez v. Bondi. And now, a word from our sponsors.
Good morning, Law Office of Aaron Gomez. Trevor speaking. How may I help you?
Hello. I came across your info on Google. Do you by any chance handle 601 waiver cases? My deadline's coming up just like a few weeks away, and I'm having trouble to get it done. Can you help me?
I'm really sorry, ma'am. At the moment, we're at full capacity. We're not taking any new cases on right now.
No way.
That's not just a lost call, that's a lost client. And it happens every day. With Staffy outsourcing, you don't have to say no. Staffy takes care of the heavy lifting, forms, document collection, assembly, and quality checks at a flat rate of $550 per case. No contracts, no hidden fees, and your first 3 cases are free. Say yes to more clients and grow without burning out. Don't just think about keeping up, think about leading. With Staffy, elevating stress and working smarter will let you double down on building your practice. Visit www.staffy.cc or call 786-891-5619 today. That's www.stafi.cc. Or, of course, click on the link in the show notes. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez Immigration Bonds take it from there. They help families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process, and they typically issue refunds within 1 to 2 weeks of receiving the I-391 bond cancellation notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your client stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40. And for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They got those too. They're family-owned and have been in business for 75 years. Gonzalez & Gonzalez Immigration Bonds. Efficient, supportive, and trusted. Visit immigrationbond.com, click on the link in the show notes, or call at 833-409-9200. Welcome to the end, with a Navy Bondi published by the Ninth Circuit on October 16th, 2025. This case is about credibility. And it's a rough one in this area, in the ever-evolving Ninth Circuit jurisprudence of just what their en banc Elam v. Garland decision truly means. Recall, after Divey Garland from the Supreme Court, the Ninth Circuit said en banc that the adverse credibility determination, adjudication really, is always a totality of circumstances analysis. Now, some panels in the Ninth Circuit have issued decisions that support an argument that say, when an IJ and the BIA rely on 4 bases to find a non-citizen not credible, and 2 of them are incorrect, a remand very well may be required, given that all 4 were previously the basis in totality, but now there's only 2. I'm not sure that this panel would agree with such a rule, and this panel has gone quite a step further. Here the panel held that Mr. Ani's past involvement in marriage fraud for immigration benefits could be grounds for an IJ to deem him not credible in his completely separate asylum claim. Mr. Ani is from Nigeria and has a very interesting asylum claim, if true. It involves his membership and activity in the separatist political organization Movement for the Actualization of the Sovereign State of Biafra, known as MASAB, described as, quote, a non-violent organization that advocates for the formation of a separate state called Biafra in the eastern part of Nigeria, end quote. He testified that some very scary and horrible things happened to him as a result. But again, he also committed marriage fraud in the United States. He and his wife at the time admitted it, in writing to USCIS. Then again, he seems to have quite the asylum claim for removal proceedings, including a germane newspaper article from 2004 that identifies Mr. Ani by name. But he also denied all allegations of marriage fraud in the removal proceedings. He claimed that he signed the marriage fraud admission under duress, that the USCIS officer, quote, threatened him with immediate detention and deportation if he did not sign, end quote. That officer, Officer Cataldo, submitted a sworn affidavit rejecting the accusation. The IJ believed the USCIS officer in court, who also admitted, though, that she didn't actually remember Mr. Ani or his case. The IJ deemed Mr. Ani not credible primarily for this reason, conceding that he was quite believable and consistent with the asylum claim, including on cross-examination. But the IJ couldn't get over the marriage fraud stuff, and especially, it seems, as Mr. Ani hadn't come clean in immigration court. After some back and forth, the BIA affirmed, including Mr. Ani's apparent failure to establish CAT eligibility independently of his non-credible testimony. As I mentioned, the Ninth Circuit affirmed the agency. Now don't get the panel wrong. Do not do it. Quote, an applicant's careless error about peripheral details does not support an inference that the applicant is lying about the facts that do matter, end quote. But also an inconsistency need not be material to the asylum claim to support an adverse credibility finding, explains the court. Not anymore, after the Supreme Court and Congress have swatted the Ninth Circuit's hands a couple of times. Indeed, even since my time as an attorney advisor in the Ninth Circuit way back when, the court has adopted the maxim falsus in uno, falsus in omnibus. False in one thing, false in everything. That's Levy Holder. Discusses the panel. Case I remember vividly from when I used to summarize circuit decisions only for IJs. Being quite clear then, quote, when applicants for immigration relief deliberately lie to immigration authorities to secure an immigration benefit, it's entirely reasonable for the immigration authorities to disbelieve their stories and deny their claims, end quote. Not required and not necessarily determinative given the totality of circumstances analysis required after alam, but reasonable. You're going to need strong evidence of truthfulness to overcome intentionally lying to immigration officials regarding important things like applications for immigration benefits. Evidence wasn't strong enough here. First, the Ninth Circuit, like the agency, believes that the record supports that Mr. Ani indeed committed marriage fraud. As such, quote, Mr. Ani's continued denial of marriage fraud before the IJ raised legitimate questions about his ability to testify honestly, end quote. If trivial fraud, probably won't support adverse credibility. This one is not trivial, though. An orchestrated effort for immigration benefits, explains the court. And all of it means to the court that Mr. Ani just can't be trusted, even if his testimony in support for asylum was quite good. Without his testimony, the Ninth Circuit didn't see a sufficient claim to asylum or withholding of removal, and Mr. Ani apparently didn't pursue the CAT denial at the Ninth Circuit. So the Ninth Circuit denied the petition for review. What do you think about all this, Kevin? Thanks for asking. All of this does have me thinking about INA Section 237A1H waivers. Be careful with your Section 237A1H strategy, folks. Think long and hard now about whether your client should challenge removability. Obviously, they should challenge removability if they absolutely didn't commit the fraud. Can't lie in immigration court, right? But this decision might make it more difficult to secure a waiver if an IJ sustains the adjustment of status fraud charge, right? Because you're not admitting to it in court, and the Ninth Circuit here seems to believe that that's quite important. Now, on the flip side, Section 237A1H is pretty much the easiest waiver to get. It has no hardship showing requirement, and the waiver is literally for marriage fraud at the time of adjustment, thereby indicating to me congressional intent to liberally grant such waivers. But you'd be crazy not to be worried about this decision when litigating the issue in the Ninth Circuit and how it may affect applications for 237A1H and other relief as well when your client has committed or attempted to commit immigration fraud in the past. Such is the case law, folks. And that is Ani v. Bondi. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.